Hello, everybody. Welcome to the Beverly Hills Bar Association webinar on the legal issues in the age of COVID-19, International Tax Update on recent April 21st, 2020 IRS Administration Guidance. And this webinar is presented by William Norman of Norman and Zach, and he will review the new developments and discuss and analyze practical examples illustrating the IRS guidance. So take it away, Bill.
Hey, good afternoon. We're going to cover today just the IRS guidance that was particular to a particular response to COVID-19 situation, and it deals with four general topics. The outlines are in the first few slides. Like, for instance, slide 2, we start with what I call part 1, which is the core of this presentation, which deals with basically foreign individuals that were unable to leave the United States, had their travel plans upset in one way or another, and therefore they may be subject to being a U.S. tax resident because of the number of days that they'll be staying in the United States. The other type of non-resident, non-citizen, if you will, are those that are working temporarily in the United States who are expected to qualify under exemptions for personal services under an applicable income tax treaty by being here essentially no more than 183 days, but are unable to leave, or it's unsafe to leave. The next slide has another group. These are foreign persons that have U.S. activities or performing services. This can be corporations or individuals. And because of their activities in the United States, the extended activities due to COVID-19 restrictions, they're unable to avoid being treated as conducting a U.S. trade or business, or under a treaty as maintaining an office or fixed place of business, so-called permanent establishment in the United States, and thereby subject to taxation on that compensation income in ways we'll discuss a little bit later. Then the last set of individuals who are obtaining relief under this guidance that was issued April 21st are U.S. citizens and residents who were working overseas, who had to leave their overseas job assignments and come home before they were able to qualify for the foreign earned income exclusion or the housing cost deduction, which requires a certain number of days abroad, either actual presence or as a resident of a foreign country or foreign countries, as the case may be in certain situations. Let's go to slide 5. This is the little background for this first set of individuals who are foreign persons who are not able to leave the United States. By way of background, how would these individuals normally avoid being resident for U.S. tax purposes? We've got several of these methods set out here. First one is they have no green card and they fail the so-called substantial presence test, which we'll get into in some detail, but it's either less than 31 days in the current year or less than 183 days determined over a 3-year period with weighting of each of the years as indicated here, 100% the current year, and 1/3 immediately prior, and 1/6 the next one. And the other method is no green card, and the individual is present in the United States for fewer than 183 days, excuse me, and has a tax home in a foreign country, and maintains a so-called closer connection to a foreign country. And we'll get into somewhat these particular conditions shortly. Third method here is no green card, and the person is so-called exempt person, which are essentially teachers, trainees, students, diplomats, um, in this category. Next slide. This other category here is the non-resident alien has no green card, is unable to leave the United States because of a medical condition which arose while the individual was present in the United States. I'm reading that exactly because it's of some importance, as we'll see later. And those days during that period, the medical condition existed, prevented the person from leaving the United States. If that was the case, those days get excluded under the prior rules we talked about. The next one is an individual doesn't have a green card or has a green card, either situation, and they're treated as a non-resident of the United States under an applicable income tax treaty, which happens to be only for purposes of the treaty. To the next slide, then. To the next one. Okay, this is the prior one. This is a list of what would be the consequences of a non-citizen of an extended stay in the United States if they weren't able to avoid non-residency under one of those sets of conditions that I previously discussed. I'm not going to go through this entire list. The very first bullet point is the major one. That individual would be subject to worldwide taxation, regardless of source, on all their income, and to the extent there's net income from business income, that would be taxable. Otherwise, if it's at regular rates. Second consequence is that if they're an officer or director of a foreign corporation, or they have ownership of a foreign corporation, they may be subject to U.S. reporting. A number of forms there we won't go through. If they're a trustee of a foreign trust, they could cause a foreign trust to become a domestic trust, which makes it a domestic person that has worldwide reporting. To the extent they're shareholders of a foreign corporation, and that shareholder becomes a resident of the United States, they could cause the corporation to become a controlled foreign corporation, which results in some inclusions without regard to distributions to the U.S. shareholders, including the individual himself, but there could be other persons implicated. And I'll leave the others to look at. The last one might be of some interest. You could become a state income tax resident. I found only one United States Tax Board appeal where there was a situation where somebody wasn't able to leave the United States, not because of a pandemic, but because of conditions in their own foreign country. And the taxpayer was not able to avoid residency for California. So look at the California rules carefully. For the next slide here. This is the substantial presence test set out a little more specifically. If you have an individual who's not a U.S. citizen, and also not a green card holder if they want to avoid residency, they fail to satisfy the substantial presence test if he or she was present in the United States for less than 31 days, or the sum of the current days and the preceding days and the days before that, as weighted, as shown here, are less than 183. There's a little formula underneath there as an inequality. I've set these rules up. The code talks about how you become a resident in a substantial presence test. I'm setting up as these slides as how you avoid it. So you want to be less than 183 days. So next slide. This is how you count the days. I'm not going to go in detail here. The very simple rule is any part of a day counts. But there's some days when if you're a commuter from Canada or Mexico to the United States, a daily commuter essentially, get to avoid those days. And persons in transit happen to land in the United States that are here for less than 24 hours and don't conduct any business, they get to exclude those days as well. But this is the rule we're normally looking at. So next. This is defining what's the United States. I won't go into detail here, but it's an important one down at the bottom, is it doesn't include airspace over the United States. So presumably coming in, if you come in and land, after midnight, the trip in doesn't count, or the other way around. If you get off in time, your airspace, if that's the next day, time over the United States won't count before you get to. If you're going to Europe, for instance, you get to over Canada. Okay, next. This is a little example illustrating the substantial presence test, and I'm going to follow this up later as soon as we talk about the exceptions, both under this RevProc 2020-20. So here we have an Italian citizen. He's got a small hotel in Venice. He normally visits the U.S. Each year. And several years ago, he was advised by his tax lawyer, to be here no more than 121 days in any given calendar year. It's kind of a rule of thumb. He wants to come each year as long as he can, but not end up triggering the 183-day or more rule, if you will, to become a resident. So I've got the math down here as to what you do here, and the 121 days. If you look at it, 121 plus 40 and should be in a sixth, and 40 and 2/6 is 182 and a half, and that gives 181 and a half. That gets them under the 183-day test. If you went to 122 days, it would not work. You'd be not less than 183 days. You did the math. Okay, next slide, please. This talks about the exemptions in more detail. Who's an exempt individual? I mentioned them briefly. Each of these is defined in considerable detail in the applicable regulations to the code section that's listed there. And so we're not going to go through these because these are not specifically changed or implicated by the guidance that's the subject of the RevProc that we're talking about today. So next slide, please. This is one of the major exemption we want to focus on for a moment. This is the one that's affected by the RevProc 2020-20. But in the code itself, it says, for purposes of this day counting rule that we just went through, an individual is not treated as president of the United States on any day where they're unable to leave because of a medical condition which arose while the individual was present in the United States. We'll come back later to parse this a little bit more as to what this means. Specifically, whose medical condition are we talking about? And there's been some suggestion that it can be that of a spouse or a child, or the person who wants to leave can be a caregiver and they can't leave because of who they're taking care of. But we'll talk about that a little bit later. Let's go to the next slide. This is an important exception here. This is in really kind of a alternative to the substantial presence test in a way. If the individual doesn't meet the substantial presence test, they can then claim this particular exemption, the coastal connection. If they're present in the United States for less than 183 days, not clear whether the presence rule excludes the days of the medical exception. It seems that it does, but it's not crystal clear in the regulations. There's no explicit statement of that, although the RevProc does seem to clarify that, at least for persons who are eligible to use the RevProc. Individual has a tax home in a foreign country, and then there's one sentence left out of here. The individual has not applied for a change of status or has not taken other steps to obtain a green card, and that's in the code section 7701B3C, which is down below, but it's not on the slide. And most importantly, the individual, this is as important, the individual has a closer connection to a foreign country. It can be foreign countries, but that's another complication we won't get into, than to the United States. So there's 4 conditions that need to be satisfied, and that exemption is claimed on a Form 8840, which we'll deal with shortly. So let's do the next one. This is the conditions for any of these substantial presence tests or the exceptions. The person is not a permanent resident, they don't hold a green card, and they haven't made a so-called first-year election, which they normally wouldn't do if they're trying to avoid being a resident. First-year election is a way to elect to be a resident under certain conditions, which we won't talk about here. So the next slide. Next one, okay. This is the new medical condition exception, if you will. It's called, the specific name is up there at the top, COVID-19 medical condition travel exception. There's a lot of definitions in this RevProc, some a little awkward. Could probably start using some acronyms, but I decided it's easier for the purpose of this webinar to just use the full names for the most part. So the first thing you need is an eligible individual, which we'll talk about, who intended to leave the United States. I've got it in quotes because there's a presumption that applies there. They're in the individual's elected COVID-19 emergency period. Elected because the individual gets to select the period. We'll talk about what that is. It's limited to 60 days and has to begin within a specific period. And was unable to leave the United States. They intended to leave, but they were unable to leave due to a COVID-19 emergency travel disruptions, or the COVID-19 emergency travel disruptions. Defined terms again. We'll get to that in a minute. What's the sense of all this? That person, we're talking about a non-resident alien without a green card, can then exclude this period, the 60 days, beginning in this period, February 1 and not later in April 1, for purposes of applying the substantial presence test that we just talked about. So 60 days get thrown out of the calculation, and only the days remaining then count, and there's another exemption that might apply. So the next slide. This just again, sets forth the 4 conditions that are required to be an eligible individual. And I'm not going to go through why their particular ones are chosen and why they make sense or don't make sense. There is a group locally in Southern California headed by Michael Carlin, which I'm a part of, and the Florida Bar Tax Section, and others that are making comments to help the IRS develop a workable relief, if you will, for worthy individuals that are caught in this situation. So some of these things may change, but the way the RevProc's written, this is what they are. So you're not a U.S. resident at the end of 2019, and you don't become a permanent resident, get a green card in 2020, and you were present in the United States, actually present, not the excluded 60 days, on each day of whatever your 60-day period that has been selected by the individual, and you don't become a U.S. resident due to days present in the United States outside of this 60-day period. In other words, after you apply that, there's no other way in which you become a U.S. resident in 2020. The next slide. The emergency period, this is the period that gets excluded. It consists of 60 consecutive calendar days. It's actually selected. by the individual. So if there's some day where you're not an eligible individual, you can lop the day off, but they have to be, you can only, basically it looks like you can lop them off only at the, well, you can shift it a little bit, obviously, within the periods within the next bullet. But it's got to be consecutive days. So you're taking it off the end or the beginning. And during that period, the individual has to be physically present in the United States. Not normally a problem because the person doesn't want to leave anyway, but we'll get to, how do they prove they were here 2 years from now? Next, please. The COVID-19 emergency travel disruption, which was back in the prior slide there, in the kind of operative rule, is defined in the RevProc. It seems not to have any operative effect the way the definitions are written, but this is it. I'm not going to go through it, except for the last one. It's kind of a little bit strange. If somebody feels unsafe due to recommendations about social distancing and limited exposure, limited exposure, although it's just limited in the RevProc, in public spaces, then that's a travel disruption. So it's a very liberal standard if it has any operative effect. Go to the next slide. And this is the important rules here. The individual is presumed to have intended to leave during the individual's selected COVID-19 emergency period, unless the person's taking steps to become a lawful permanent resident, being a green card. So it's a presumption that's there. And let's go to the second one, the next one. Also intended to leave. Excuse me. We go to the next slide. Same one. They're presumed to be unable to leave on any day in the individual's COVID-19 emergency period for purpose of the substantial presence test. The presumptions don't pick up the due to language that's back in the original operative slide about due to COVID-19 travel disruption. Just shorten it a little bit. But it appears that this is sufficient, these two presumptions, to qualify regardless of any need to prove that there's been a travel disruption under that slide that lists all of these things, including the feeling of the traveler. For the next slide. COVID emergency is defined as it means the global outbreak of the COVID-19 virus. And then it says the COVID emergency is considered to be a medical condition that prevents the eligible individual from leaving on each day during the individual's emergency period, as required by this general medical condition exception. It's also not treated as a pre-existing condition, so it doesn't matter when you came versus when the COVID-19 conditions prevented you or made you feel that it was unsafe to travel. Let's go to the next slide. We have some procedures here as to how you qualify. They're somewhat different than the ones under what I call the medical condition travel exception under the code. So I'm just going to go to the next slide. We'll skip through these. Let's go to the next one. Next one. This is information about how to fill out the Form 8843. Let's go to the next one. That's the form, or at least the first page of it. Second page maybe there. Go to the next slide. Now there's the second page. Excuse me, go back one. We looked at part one is to be filled out, and then those instructions that are on the one slide, they're dealing with part 5, and the particular lines there. One important one is line 18 in that prior slide, and in the RevProc, it says you don't have to have a physician's statement to claim the COVID-19 medical condition exception. Next slide. Let's talk about some other conditions here. This one, I've taken some statements out of the RevProc. Um, this particular one I think is especially important. It says an eligible individual may claim, or at least part of it, an eligible individual may claim the COVID-19 medical condition travel exception. That's what we just talked about. And then it says, in addition to, or instead of, claiming other exceptions from the substantial presence test. So the in addition to or instead of, in addition to would indicate that you could, they call it double dip or maybe triple dip, depending on your circumstances, the various exceptions to avoid triggering being a non-resident alien for a particular calendar year, either the current year or some subsequent year. Let's go to the next slide. These are the other exceptions that are listed in the RevProc we've already talked about. The exempt individual, which is listed there. The next slide, please. The ones that the COVID medical condition travel exception, which we just talked about. 180, fewer than 183 days with a tax home and closer connection and no application for change of status or steps to change status. And then one that's introduced here in this presentation is individuals who are resident of the United States in another country and claim to be a non-resident of the United States, maybe a resident of that other country, under an applicable income tax treaty. And that's not day counting for the most part. That's a more factual test that we'll maybe talk about in a few moments here. The next slide. This is the other, some of the procedural rules that have to be satisfied here. I've got the form numbers for each of these exceptions that you can see here. The treaty exemption has its own form in 8833. Some question whether you can claim the exemption without filing the form. If you don't have reasonable cause for not filing the form, there is a penalty provided, so one would want to file the form, regardless of whether it's absolutely necessary to be exempt. Next slide, please. Okay, now we have a series of little case studies I put together with Luigi Bellini concerning application of some of these rules. Just give you a little flavor for how they might work in real life. So in 2020, Luigi landed at LAX at 12:30 p.m., which means, you know, that if he had landed earlier, he would have had another day, but his day starts on February 1. He normally comes to the U.S. each year, but because of flooding in Venice, had to delay his trip. Obviously, just a little background here. Now it's May 7th, and he feels it's unsafe for him to return to Italy. Obviously, reading the papers, or more likely watching TV. He doesn't want to take, you know, even local transportation if he could even get a return flight. So his tax lawyer tells him he can elect to exclude 60 consecutive days, beginning on any date in the period February 1 to April 1. And the consecutive period can go past April 1. That's just when it has to start. And without the medical travel exception, Luigi would have only 24 more days to stay in the United States. He's got 29 days in February, happened to be a leap year, 31 in March, 30 in April, and we're at May 7th, so he's got 97 days. He's trying to meet this 121 because of prior years where he has 121 days in 2019 and 2018. You can work that through, but it had to be 121 or less in this year to avoid that 3-year period applying. So he's got 24 more days under the code rules. Under the RevProc, he's got another 60 or 84 days. Next. So here is, he's always thought his long-term tax lawyer was very sharp, but he's has a lot of time on his hands now. So he read or looked at a very confusingly written blog that seems to indicate he could stay longer than 181 days and still avoid being a resident for income tax purposes. The blocker called her plan the double dipper. So Luigi then consults another tax lawyer who tells him he can stay in the United States in 2020 as many as 242 days. And this tax lawyer computes the permissible days as follows. He's got the same 97 days, go out to 60, assuming the COVID-19 medical condition travel exception applies. So he's got 37 days. Under the 183 day, really, less than 183 days, but say 182 days he can stay. We start with the 37 days is already here. The 60 are gone. He's got 145 more days, which means that the total days, we go back to the beginning, through May 7th, he's got 97 of actual presence, plus another 145. He can be here 242 days. So we assumed that the medical condition travel exception, the COVID-19 medical conditions of travel exception, and the closer connection exception can both apply. And that was this prior slide we had where it said the exceptions in addition to this medical condition travel exception can apply. So in addition to could reasonably be read as allowing both conditions to apply. Let's go to the next slide. Luigi, has done a ton of Italian tax planning over the years. And he senses that maybe this advice is too good to be true, or maybe too good to be true. So he consults a third lawyer. And the third lawyer opines that the double dipper works. You can use both the COVID-19 medical condition travel exception and the fewer than 183 day social connection test in the same year. But he says, what about your annual visit in 2020 or 2021? So he does a little calculation here, taking the days that we have. 2019 we already have, 2020 we already have. If we go to the full days there of 182, we get to presumably avoid the 60 in 2020 when we're doing the calculation in 21. And then how many X's, how many can he have in this current year? And it comes down that he can stay under 183 days in 2021. He stays 102. So his tax lawyer says, well, you can only stay 102 days in 2021 without becoming a U.S. tax resident. Let's go to the next slide. Luigi doesn't give up. He feels like he's been on a roller coaster. He decides to consult one more tax lawyer to nail these matters down. This lawyer tells Luigi, don't worry about 2021. You can claim to be a non-resident of the United States in 2021 under the United States-Italy income tax treaty. Luigi wants to know how long that means he can stay. The tax lawyer responds, as long as you're a resident in Italy for Italian tax purposes and have a permanent home available to you only in Italy, meaning not in the US, it seems you can stay the entire year. However, I need to do a little further research on this issue, but you should be able to stay your usual 121 days. Then the tax lawyer, she continues, before you go to another tax lawyer, I want to tell you that as a treaty non-resident of the United States, you would have to file a Form 8833, certain reports concerning your non-U.S. financial accounts and foreign financial assets such as shares and foreign corporations and your U.S. partnership interests. There are certain forms that you can avoid, the 8838, for instance. not the 5471 if you're familiar with those, and probably not the FBAR. In any event, also he might become a resident of New York or California. California doesn't have a day counting rule, but it does have presumptions if you're here more than 9 months. As I mentioned earlier, there's situations where, at least one situation where a foreign person was unable to go home because of political conditions in his home country and was held to be a resident of California. I didn't look at the New York cases, but I know they're strict. So Luigi asks, finally, how can I avoid having to consult so many tax lawyers next time I have a simple U.S. tax question? Of course, the answer is you watch the Beverly Hills Bar YouTube channel, as this particular webinar will be found, as well as many others, on COVID-19 and also on tax issues. Let's go to the next slide. This is the Kosher Connection form here. I won't go through it. You can see in part 3, you need to explain, why you've got a kosher connection. In the Treasury regulations, there's a long list of factors that need to be considered, which in writing this statement you want to negate or explain if you can't satisfy, if you're subject to one of these factors of showing lack of a kosher connection. Also, there's a list of various immigration forms that you should not have filed if you want to say you have not applied for a change of status. So it's not an exclusive list, and you need to check Google the current immigration site to see if there are any other forms that supersede that list. I didn't check all the forms. There's quite a list there. Let's go to the next slide. This is the treaty-based return position disclosure form, which is that the fourth lawyer was suggesting that Luigi use for 2021. And you can see it's line 6, where they're asked to explain your treaty-based return position, a summary of your facts. I won't read the whole thing there to you, but they got a few lines here, and somebody takes more than that, but there's not a short answer response, let's put it that way. And I would spend some time working on this particular form if you want to avoid at least an inquiry and maybe an audit. Let's go to the next slide, please. The next few slides are a few technical issues dealing with the application of RevProc 2020-20 and also the code itself. I'm not going to go through all of them, but I pick out the ones I think are most practical to discuss here. The others are for a different type of discussion, if you will, that we can do on this webinar. First thing is, how do you document that you're physically, your client or the eligible individual, non-resident alien, or the alien, we don't know if he's not a resident yet, has been physically present in the United States for the entire COVID-19 emergency period, which is a 60-day period that's elected. The RevProc itself does not indicate the type of documentation that would be acceptable. I've got some suggestions here. A personal diary, which we typically use for travel expenses and usually for meal entertainment, that kind of thing. Car expense, that kind of thing. Hotel statements, though you can have a hotel room and be gone. Car rental. None of these are determinative. I-94 travel history. Take a look at that site. It says it's not determinative for some reason. I guess sometimes they wave you through on the way to Canada. I'm not sure. But if you come back, you end up with 2 admissions, and where were you between the two admissions? So there may be this may be good evidence in many cases as to where the individual is. The passport stamps themselves, again, the passport has got stamped on anything that leaves by land. I don't think boats are traveling, but the boats, sometimes have different procedures as well. All right, so let's go to the next one here. Next slide. The other one is you can't be a U.S. resident. This is to be an eligible individual to use this COVID-19 medical condition travel exception. You could have been a U.S. resident at the close of 2019. The question, right, what if you're a non-resident under an income tax treaty, which we talked about earlier? Well, if you look at the regulations, at least, they're saying that a treaty non-resident is would otherwise be a resident of the United States, other than for the computation of income tax liability. And now a filing of one or two IRS international reporting forms, 8938, one coming to mind. But otherwise, you're still a resident, whatever that might mean. But it might mean that for purposes of this RevProc, you don't satisfy the eligible individual, therefore you can't exclude the 60 days. Go to the next one. This is use of other exceptions. This is from the RevProc itself, with a lot of ellipses in here just to show you, focus on the important language. This is relief under this revenue procedure, meaning RevProc 2020-20, does not change the application of other applicable exceptions. Some people read that as, well, you can double them up, medical conditions, and the closer connection test. Others say that, well, whatever the code was, you can't do more. And the code and regs are a little clear about how the closer connection, fewer than 183 days, works with the exclusions under the medical condition. There are different exceptions, and you can read them both ways. I think they were meant to be doubled up under the code, but it's not crystal clear. And I didn't find anything to the contrary. I didn't read all the instructions, but didn't find anything in doing a little electronic research on that. For the next slide. This is the language that I think helps you, at least for those that are eligible individuals, to use the fewer than 183-day closer connection test and the COVID-19 medical condition travel exception in this for the same, obviously for the same year, 2020, because this is another quote from the broken up a little bit to be a little easier to read, but it says that the medical condition travel exception can be used in addition to claiming others. And it says, or instead of would mean you got one or the other. Addition to would mean you can double dip or triple dip, whatever it happens to be. Let's go to the next one. It's just some more statements here saying that if you use the COVID-19 medical condition travel exception, you can also use the other medical condition if you meet the requirements, whether it's related to actually getting the virus or not. You really can't leave. Then those dates should count as well, and you should be able to add those on, referring to the prior slide, to your medical condition travel exception period of normally 60 days. All right, let's go to the next one. This is a statement that's also found in the RevProc. This doesn't have any ellipses in it. This can be read as saying you can use both the COVID-19 medical condition exception and the 183-day together. Although one could read it as an alternative, but I think given the prior one of the prior slide where we talked about this condition being in addition to, one would think you could use both. So the next one. This is just more statements from the RevProc. The last one is kind of a contrary to double dipping. It says, the relief provided under this REV procedure does not change the application of the other applicable exceptions, which would seem to say, we read it literally, but not looking at the other provisions that we talked about. If you exclude 60 days, then when you look at another exception, you can't exclude the 60 days. But this is not consistent with this addition to or instead of language that we read earlier. For the next slide. Let's skip this one. If you will. The next one. So let's skip this one as well. I'll leave these for you to read. And let's go. Let's keep going. Skip one more. This one I just focus on for a moment. Some practitioners have suggested that the medical condition, or a medical condition, get the language from the code, you should put that in quotes, need not be the condition of the claimant, that is the taxpayer, of the exception, but can be the medical condition of a child, spouse, or the patient or the caregiver that has a patient, for instance, or the caregiver of a patient. It goes either way. The problem is the code just says a medical condition, and one would think if it was to be a class of individuals that could claim it, there would be a prepositional phrase after it listing who these people are, maybe limiting who they are. The general medical condition exception is limited by the intend to leave and unable to leave language. So it doesn't completely foreclose reading a medical condition as being the medical condition of someone other than the claimant. I looked at the legislative history. The example is of a claimant who's in a serious automobile accident shortly before a planned departure date. So it's not the family member of the individual that has the accident. It's the individual, him or herself. And so I think the better interpretation, we're talking about the intent at least, was that the medical condition meant the medical condition of the claimant, not someone else. Although if the service is willing to have a broader reading and some notice, then obviously we'll take it. Let's go to the next one. Capital gains. Let's skip through that. There is some question about, well, not a question, that when you start excluding days in a substantial presence date, it doesn't affect the rule that some non-resident aliens that have a tax home in the U.S. Would be subject to U.S. source capital gains if they're present in the United States for 183 days or more. It rarely comes up because the person has to have a tax home here, which affects, and also the capital gain has to be from a U.S. source, and that requires that there be a tax home in the U.S. to even have U.S. source capital gain, except for real estate, U.S. real property interest. Let's go to the next one. Now we're talking about the second exception. We're going to go quickly on these. This one is there's a relief for day count under U.S. income tax treaties when somebody's performing basically as an employee, somebody being an alien in the United States would be a non-resident alien, and that employment income is exempt if they're present in the United States for periods not exceeding 183 days in any 12-month period, and it wasn't paid on behalf of the U.S. person and not borne by a U.S. permanent establishment. That's just an example from a particular treaty. Many treaties have this, but I just picked this one, an example. Let's go to the next one. What's the relief under this? Well, if the individual is claiming an exemption under income tax treaty for income from employment or dependent personal services, they will be presumed to be unable to leave the United States during the individual's COVID-19 emergency period, which is defined as this same way as we previously mentioned with respect to the medical condition. There has to be a selection within this particular period. For the next slide. The relief is allowed if for any days are present during the COVID-19 emergency period in which the individual was unable to leave. Presumably it's that same presumption, is the same presumption, I'm sorry, as applied to the medical condition exception. It's got this due to COVID-19 travel disruption. It's part of what I talked about on those slides we skipped over with some technical comments. It seems like the due to language is not needed. If you're unable to leave, you're presumed to be unable to leave during this period, and that's really all you need. You don't have to prove that it was why you were unable to leave. But there seems to be a little sloppiness in the language. Let's go to the next one. This is how you claim it, but we'll skip over this. It's another form 8233. For the next slide. Some more about what happens if you've already got an exemption with your withholding and you don't have to do it again. Let's go one more here. Keep going. Next. There's the form. We only have part one of this, but there's a second page of this. Let's go to the next page. Next slide. Some more procedural aspects on how you do it. Let's keep going. Next one. This is the third exemption here for relief. It's a foreign person who are temporarily in the United States performing services or conducting activities in the United States, but would have left before they would be treated as conducting a U.S. trade or business, or would be treated as having a permanent establishment. Next slide, please. This is just some more what the underlying law is. Let's go to the next one. This is there's a question. It's kind of a Karnak thing here. I'm giving you only the answers. But the question is the inverse of what we have here. Basically, what's the relief for people in this situation? Well, non-resident alien or a foreign corporation or a partnership that has, a non-resident alien or a foreign corporation as a partner, they choose to a period of up to 60 days, which is this COVID emergency period. And during the period, something takes the services or activities are conducted in the United States, they'll not be taken into account in determining whether the alien or the foreign corporation is engaged in a United States trade or business. If the activities would not have been performed but for the COVID-19 emergency travel disruptions. The Q&A doesn't have really presumption, so what's the but for language? You have to prove something here. This, again, needs some more work on it to be a useful Q&A. Also, it just changes whether you have a trade or business. It doesn't change generally the source of the income that the individual receives. So they still be taxable, just not as trade or business income. Next slide. This is who's a U.S. individual temporarily present in the United States. That's the first part of the answer there. It's somebody who's present on or after February 1 and on or before April 1. So just a 2-month period there. And it's and is a non-resident alien really is not is a non-resident alien or not didn't have a tax home, had a tax home outside the United States. So the first part is not a non-resident alien who's not a U.S. citizen or lawful permanent resident who had a tax home outside the United States. The reference to 9/11 is just a definition. And reasonably expects to have a tax home outside the United States in 2020. So you have to get what's a tax home, which is your usual place of business. The same rules you use when you're on a business trip and you're away from home. That same standard. For the next slide. This is really the same question, except this time they're talking about the foreign person who's a corporation or an individual, and they're claiming to not have a permanent establishment, but is not conducting business to a permanent establishment, which will exempt certain income, but not necessarily a certain investment type income that would not otherwise be attributed to the conduct of business to a so-called permanent establishment, which is just an office or fixed place of business. For the next slide. This is the last one here in this device. This is in RevProc, will come out in RevProc 2020-27. That hasn't come up on the slide yet. So we're talking about a qualified individual can elect to exclude certain foreign earned income and certain housing cost amount. These are typically U.S. residents or citizens who are working overseas. The next slide. This is who a qualified individual is. They're going to tax home in a foreign country. It's again the principal place of business, typically, not just temporarily there, away from their regular place of business. There's two alternative prongs here. Either a citizen of the United States and a bona fide resident of the foreign country for a period that includes an entire taxable year, or you're a citizen or resident of the United States. So a resident of the United States could qualify here, a green card holder, for instance, who during a 12-month period is present in a foreign country or foreign countries for at least, should be 330 days. Somebody edited this a little bit, 330 days. Let's go to the next slide. So here we have an exception that's in the code, and it says if this U.S. individual couldn't stay in the United States, couldn't stay overseas, they had to come back, at least leave the foreign country because of basically civil unrest or other conditions in the foreign country, then they're still treated as satisfying either the residency in the foreign country or the 330-day test. Let's go to the next one. Next, please. This is an example that's in the RevProc itself. So it said, well, no, next one is. This is the Secretary of State has determined that after consulting with it's actually the Treasury consulting with the Secretary of State that we have an adverse condition, and the PRC excluding Hong Kong, Macau was as of December 1, 2019, or otherwise it's February 1, and the period can't go longer than July 15, 2020, unless extended. Next slide. If they do that, and they left after that period, so they had to be there before, it'll be a qualified individual. If they had a reasonable expectation, they would have met the bona fide residency test or presence test. And the next slide, the individual established physical presence on or before this applicable date. So that's the next slide, please. The relief here is that if the individual reasonably expected to be present in the foreign country for 330 days, but for the emergency and met the other requirements, it may use any 12-month period to meet the qualified individual requirement. Even though you qualify, you can only exclude, if you will, income that's attributable to actually performing services in the foreign country or costs incurred for housing in the foreign country. For the next slide. Here's the form that filed here. We won't go through this. I think that takes us to the end here. Alex, do we have any questions? Should I look somewhere on the? Okay, it says if they don't have if they're not resident in a single country, they're still protected. There are some special rules that deal with the people who have, more than one country. I think best if this person would because of all these dates in there, I think it'd be best if this person send me an email. I'll respond to it. Because he's got, I just don't want to go parse through all of these dates. I think it'll take us off point a little bit. So Greg, maybe just send me an email. I'll answer it. Here's the next one. Are you coming across investor visa foreigners, asking about if it's still available? Well, I guess if the office is open, it's an immigration law question. It's a matter of practice whether they're accepting these applications. I don't do immigration law, I just advise on tax aspects. So I suspect this is it's going to be very slow if it's available at all at this point. It's not formally closed, but I don't know what the practicality of it is at this point. Next one is, Mr. Norman, how can I learn more about structuring a U.S. trust for non-U.S. persons that will not be taxed? Can you roll that up a little bit? Alex, it'll be rolled up a little bit. Will not be taxed in the United States, I guess what he's saying.
Yeah, it's in the United States.
Well, not from this presentation. Okay. This is a kind of a separate topic. I don't think we've had a recent program, the Beverly Hills program on this. I did this a while back for the CEB Annual Estate Planning Institute that they do with UCLA. And I think it was also covered at the USC Institute. If you got somebody who got those materials. Otherwise, you might Google it. There's some good articles on it that may be readily available. That's about all I can help on that. Or send me an email and I'll see if I can do a little more work for you and find a citation that you can access. Okay, well, if that's it. If anybody comes up with anything else, send me an email. The email's on the first page. This is one from, I'm on the chat box. It says, any thoughts on whether the clause which arose while applies to any wrinkles if a person and their spouse enters into an elective medical procedure then stays because they are on AC inhibitors, or I don't know what these things are, but I should, I guess, or simply because of fear. Well, you need to have the dates. You can always if you meet the requirements of being an eligible individual, you can automatically exclude the 60 days. Now, if you get into your own condition here, let's just take the person who actually has the procedure. The fact it's elective, I think, has no relevance. But if you stay because they found something, that's a condition, the way I read the regulations, that the individual became aware of in the U.S. It doesn't matter. It's been, let's say, percolating, if you will, or latent for some period of time. It's when you become aware of it. So that would be a medical condition. I guess the question is it stopping you from, or are you unable to leave, and do you establish an intent that you intend to leave within the requisite period? So if you're presumably outside the 60-day COVID emergency period, you then have to meet the actual tests that are in the code in that form 8843. So you need to intend to leave, which means you get a airline ticket or the best way to do it. An open jaw, I guess, it just goes out of the United States, doesn't come back. And then include this fear, I think, that works, I think, only during your 60-day period. If the fear is because of what it's going to do to yourself, and the physician says that means that you're unable to leave without serious risk to yourself, I think that would qualify. But if it's just a fear because you've been listening to the TV or seeing things on the internet, it's probably not going to qualify outside of that 60-day period. I think that's the best I can do with that one.
Okay, and I think we're already out of time on this webinar.
Okay.
I don't see any other questions. Yeah, thank you very much, William. It was a very informative presentation.
Okay. Well, thanks all for listening, and we're looking forward to hearing from you if you have any questions.